Section 6. Federal laws that govern your work. You are asked to be an expert in an ever-evolving area of law that covers a large portion of state and federal law. Guardians ad litem must be experts in Title 14 of the Wyoming State Statutes and knowledgeable in the areas of family law, adoption, guardianship, termination of parental rights, child support, and criminal law. GALs must also be experts on various federal laws and have a working knowledge of many more. In this section, we will review a number of these laws in the areas of child protection, education, and delinquency. We will discuss relevant case law and then highlight information pertaining to child custody issues occurring across state lines. The first of the federal child protection laws we will review is the Child Abuse Prevention and Treatment Act of 1974. The Child Abuse Prevention and Treatment Act, or CAPTA, provides federal funding to states to assist in responding to cases of child maltreatment. CAPTA includes numerous requirements which a state must meet to receive federal funds. Requirements include a mandated system for reporting suspected child abuse or neglect, assessments to determine which reports of abuse or neglect are valid, and responses that are appropriate based on the level of risk to the child. Of particular importance is CAPTA's requirement that a guardian ad litem be appointed to represent a child whenever judicial intervention is necessary. Although CAPTA does not require that the GAL be an attorney, it does require that he or she receive training in the role of a guardian ad litem. The role of the GAL is to obtain firsthand a clear understanding of the situation and the needs of the child, and to make recommendations to the court concerning the best interest of the child. CAPTA also requires training for any of the state social workers who are involved in family services and disclosure of information to government entities. It requires mandatory child abuse reporting and provides minimum standards for defining physical child abuse, neglect, and sexual abuse. Wyoming statutory definitions of child abuse and neglect conform to CAPTA's minimum standards. The Adoption Assistance and Child Welfare Act, AACWA, established Titles 4B and 4E of the Social Security Act. The AACWA has two primary goals. First, to reduce the number of children entering the foster care system, and second, to reduce the length of time children remain in the foster care system. In order for a state to be eligible for funding under Titles 4B and 4E, a state must comply with certain requirements. Title 4B requires a state to develop a plan to prevent and respond to child abuse or neglect cases. Title 4E provides federal funding to assist in offsetting the costs of foster care when children are removed from their homes. These titles also provide federal adoption subsidies for special needs children, older children, and children with emotional or behavioral problems. For each individual child who is found to have been abused or neglected, Titles 4B and 4E require that reasonable efforts are provided to prevent removal of the child from his or her home, that reasonable efforts are provided to reunify children with their families, and that permanency planning be provided for each child. Permanency planning requires that appropriate services are made available and that sixth-month reviews take place to monitor progress. Titles 4B and 4E are particularly relevant to your practice as a guardian ad litem. These titles drive much of what the Wyoming Department of Family Services does in a case. Failure to follow these mandates can have significant consequences for DFS and the child, as funding could be lost and permanency for a child could be delayed. In order to receive Title 4E funding, the juvenile court system must follow certain requirements within a prescribed timeline. First, the court must find that it is contrary to the welfare of the child to remain in or return to the child's home. These findings must be contained in the first court order following removal of the child from his home. A case plan must be developed within 60 days of the date that the child was removed. Within that same 60-day period, reasonable efforts must be made to prevent removal. Every 6 months after the child enters foster care, a 6-month periodic review is required. Wyoming statute requires these hearings take place every 6 months from the actual date of removal. The Adoption Assistance and Child Welfare Act requires a permanency hearing occur 12 months after the child enters foster care and every 12 months thereafter. Wyoming statute requires that these hearings occur every 6 months from the date of the actual removal. The GAL should request that the order following this hearing be titled Permanency Hearing. AACWA requires that reasonable efforts to finalize a permanency plan be made every 12 months from the time a child enters foster care. Wyoming statutes require these hearings every 6 months. And in Wyoming, the time is measured from the date of the child's removal from his home. Finally, when a child is in foster care for 15 of the last 22 months, AACWA mandates filing a petition to terminate parental rights. As you work through your GAL caseload, it is critical that you keep these dates and timeframes in mind to ensure that all cases are handled expeditiously. The Adoption and Safe Families Act of 1997, or ASFA, is an extensive federal law that provides specific requirements for states when developing child welfare law practices. Wyoming law has adopted these provisions, and they dictate how each of your child welfare cases progress. A comprehensive understanding of ASFA as it is embodied in Wyoming law is essential in order to advocate as a guardian ad litem, since ASFA's provisions lay the groundwork for what we do every day. It is important that you review Wyoming statutes to gain a complete understanding of how these provisions have been codified in Wyoming. ASFA amended Titles 4A and 4B of the Social Security Act. It continued to provide funding to support both family preservation and reunification, but ASFA made it clear that in determining reasonable efforts at preservation and reunification, the child's health and safety should be paramount. So what are the reasonable efforts required by ASFA? Although not specifically defined, ASFA requires that the state agency establish a written case plan which details the child's placement, school, medical provisions, and other information. It further requires that services will be provided to assist in reunification, or if reunification is not the goal, the services that will be provided to reach an alternate permanency goal. ASFA also continued the requirement for 6-month review hearings and added that a permanency hearing must be held at least once every 12 months while a child is in foster care. The 15 of 22 rule was also established by ASFA. It requires that a state agency seek termination of parental rights when a child has been in foster care for 15 of the most recent 22 months, unless one of the enumerated exceptions applies. There are 3 exceptions to this mandatory termination provision. 1. For children who are being cared for by relatives. 2. If the state agency has documented a compelling reason why termination is not in the child's best interest, or 3. If the agency did not use reasonable efforts to reunify the family. The purpose of this rule is to ensure that children do not linger in the foster care system without progress toward permanency. The 15 of 22 rule is extremely important for GALs to understand. It is a powerful legal tool that can be used to reach permanency for your clients when their parents delay progress or when they are simply incapable of meeting the requirements of their case plans. To learn more about Wyoming's 15 of 22 rule, see Wyoming Statute Section 14-3-431, Section M. Another part of ASFA clarifies that reasonable efforts toward reunification may not be required in some cases, specifically when the harm done to a child is significant. In some situations, ASFA even mandates that the state proceed immediately to a termination of parental rights. Wyoming Statute 14-2-309C mirrors ASFA's specific circumstances when reasonable efforts toward reunification need not be observed. ASFA's overall emphasis on permanency is also seen in its expansion of alternate permanency options. One such alternative is the permanent guardianship. In addition, there is APLA, or another planned permanent living arrangement. Finally, ASFA has increased adoption subsidies and incentives as an added means of finding permanent homes for abused and neglected children. The Multi-Ethnic Placement Act and the Inter-Ethnic Adoption Provisions, collectively referred to as MIPA, was enacted to eliminate the consideration of race, color, or national origin when licensing foster parents and when making decisions for foster care or adoptive placements. MIPA requires that state social service agencies make diligent efforts to recruit foster and adoptive parents that reflect ethnic and racial diversity. The intent is for children to be placed in foster homes or adoptive homes of similar racial or ethnic backgrounds. MIPA prohibits the use of race, color, or national origin to deny eligibility for foster care or adoption or to become a foster or adoptive parent. But recognizing that there may be a lack of racially or ethnically congruent families available, the Act also prohibits delays in placing a child in order for him to be placed in a racially compatible home. Race, color, or national origin can be considered in very restricted circumstances, such as when an older child wishes to be placed with a family of a particular race or has a special need to be placed with a particular race. Keep in mind that MIPA does not apply to any child who qualifies as an Indian child under the Indian Child Welfare Act. Those children who remain in foster care until they reach adulthood have some additional needs which are addressed in the Foster Care Independence Act, often referred to as the Chafee Act. The Chafee Act was established to assist children remaining in foster care until the age of 18 transition to independence. The Chafee Act authorizes the provision of independent living services, which include educational services, employment services, such as job placement assistance, self-care services, and Medicaid eligibility. Along with assistance in obtaining a diploma, the Chafee Educational and Training Vouchers was added to the Chafee Act of 2000 to provide federal funds of up to $5,000 per youth per year for former foster youth to help pay for post-secondary or vocational education. Chafee self-care services include financial and housing assistance along with counseling if needed. The Chafee Act also authorizes states to extend Medicaid eligibility to former foster youth to age 21, and it mandates that a portion of federal funding be used to assist former foster youth to the age of 21. The Fostering Connections to Success and Increasing Adoptions Act, referred to as the Fostering Connections Act, is also directed toward older foster youth. The Fostering Connections Act allows states to continue to provide foster care services to youth up to the age of 21 as long as one of several conditions applies. If the youth is completing a secondary education program or a program leading to an equivalent credential, then the youth can remain in foster care. If the youth is enrolled in a post-secondary or vocational school, he can remain in foster care up until the age of 21. 18 to 20-year-old youth who are participating in a program designed to promote or remove barriers to employment are allowed to remain in foster care, as well as those who are employed at least 80 hours per month. In addition, those youth who are incapable of performing any of the previous activities due to a medical condition are allowed to stay in foster care as long as the child's incapability is supported by regularly updated information in his case plan. Children over the age of 18 may also continue to be eligible for foster care payments if they are living independently but in a supervised setting. Finally, the Fostering Connections Act also provides funding for relatives who take guardianship of children in foster care. On a final note, it is the Fostering Connections Act which requires clients to stay in their home school if at all possible. The next law for us to review is the Child and Family Services Improvement Act. It requires that the court consider the wishes of older and transitioning youth when making permanency decisions or developing transition plans. The court must consult with the youth about these decisions in an age-appropriate manner. This act is particularly important for you as the child's guardian ad litem, since you must ensure that the youth are available to participate in the court proceedings and that they are well prepared. In addition to laws dealing specifically with child care and protection, GALs must also be familiar with two other areas of the law affecting child welfare, namely education and delinquency. The Individuals with Disabilities Education Act, or IDEA, is relevant to your work as a GAL because many of the children you represent may have a disability that impairs his or her ability to benefit from a free and appropriate education. This includes being able to attend school, get from classroom to classroom, use the technology, and more. The IDEA requires an evaluation if a child is suspected of having a disability to determine whether the child has a disability that requires special services in order for him to learn effectively. If special services are necessary, a team is developed to draft a written individualized education plan, often referred to as an IEP. An IEP details the child's academic and functioning levels, the services necessary, the child's goals, and other relevant matters. Your client will need a parent or guardian to advocate for her needs during the IEP process. The school district must appoint a parent or guardian in every case where the child is in the custody of the state. This person may be the child's foster parent, a worker from the Wyoming Department of Family Services, or another appropriate adult. The biological parent and the guardian can both consent to the evaluation or for services to be provided. The IDEA sets forth specific restrictions on the IEP process, including provisions for dispute resolution and enforcement and complaint procedures. The Juvenile Justice and Delinquency Prevention Act, referred to as JJDPA, provides federal funding to states that comply with its requirements regarding children in delinquency proceedings. The JJDPA has 4 primary requirements. First, it requires deinstitutionalization of status offenders. Status offenders include activities such as truancy, runaway, and curfew violations. States are prohibited from holding children who engage in status offenses in secure facilities unless the court issues a detention order. Next, JJDPA requires jail removal. Children cannot be held in adult secure facilities unless a limited exception applies or unless the child is being tried in an adult criminal court. Third, JJDPA requires sight and sound separation. If a child is detained in an adult secure facility, he or she must be separated by sight and sound from the adult detainees, unless the child is being tried in an adult criminal court. Finally, the law speaks to the issue of disproportionate minority contact. It stipulates that states must address any disproportionate representation of children of color in their juvenile justice system. Along with legislation, specific case law provides insight into the rights of children and their parents in the juvenile justice system. Understanding the implications of these rulings will be invaluable as you advocate for your clients. In re Gault concluded that the Due Process Clause of the 14th Amendment to the United States Constitution applies to children involved in delinquency proceedings. In these types of proceedings, children have the right to notice of the charges, confrontation, cross-examination, counsel, and the prohibition against self-incrimination. This ruling applies to children involved in delinquency proceedings. It does not apply to children in abuse or neglect and dependency proceedings. In Kent v. United States, a juvenile court transferred jurisdiction of a 16-year-old child's criminal trial to an adult district court without first holding a hearing or allowing the child's attorney access to the child's social services file. The United States Supreme Court held that the child was entitled to due process before a transfer of jurisdiction could occur. Due process required at least a hearing and counsel's access to the child's social services file. Santosky v. Kramer held that the burden of proof in a termination of parental rights case is clear and convincing evidence. This ruling is based on the finding that parents have a fundamental liberty interest in the care, custody, and management of their children. Therefore, under the Due Process Clause of the 14th Amendment to the United States Constitution, in an action in which the state seeks to terminate parental rights, the state must prove its case by clear and convincing evidence. Finally, in Troxel v. Granville, the state of Washington statute provided that any person could petition the court for visitation rights, and that the court could grant such rights if it was in the best interest of the child. In this case, the mother allowed the grandparents 1 day of visitation with their grandchildren per month, The grandparents petitioned for additional visitations, which the court granted over the mother's objection. The Supreme Court held that the statute violated the mother's due process liberty interest in the care, custody, and control of her children. Parents have a constitutional liberty interest in the care, custody, and control of their children. It is presumed that a fit parent makes decisions that are in the best interest of their children. In determining what is in a child's best interest, the court must at least consider the decisions made by a fit parent. In today's mobile society, it is possible and likely that family members will move not only across town but across the country, complicating questions regarding a child's welfare and placement. As a result, there are several pieces of federal legislation related to interstate child custody and protection issues. The Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJEA, was enacted to avoid jurisdictional competition and conflict between courts of different states in child custody matters. The purpose of the Parental Kidnapping Prevention Act, or PKPA, is to determine which custody decrees are entitled to full faith and credit. A child custody proceeding is a legal proceeding where legal or physical custody is at issue, or where visitation with a child is at issue. Child custody proceedings can arise as a matter of any number of situations, including divorce or separation, abuse or neglect, dependency, guardianship, paternity, termination of parental rights, or when protection from domestic violence is needed. In matters of interstate child custody, the UCCJEA primarily determines which state shall proceed and which states shall abstain. The PKPA determines which custody decrees are entitled to full faith and credit. The Uniform Child Custody Jurisdiction and Enforcement Act includes provisions for enforcement of out-of-state custody orders and applies internationally. The Parental Kidnapping Prevention Act does not apply outside of the United States. Interstate considerations to look at under the UCCJEA include priority jurisdiction to the home state, significant connections jurisdiction, forum nonconveniens, and vacuum jurisdiction, which sometimes referred to as no other state jurisdiction. You must also consider exclusive continuing jurisdiction to modify, provisions for out-of-state evidence, and emergency temporary orders jurisdiction. Be sure you understand that the rules that govern courts' jurisdiction to make an initial custody determination are different from the rules governing jurisdiction to modify an existing order. Let's look at some practice points for cases where the Uniform Child Custody Jurisdiction and Enforcement Act is involved. First, review the file and interview your client and the family carefully to see if the child has ever lived in another state. This is to determine whether any other state has grounds to hear a case. If so, the court may not make a custody decision. If the family has moved from another state, look for court orders regarding custody. Is there continuing exclusive jurisdiction to modify in another state? Look at significant connection jurisdiction. Is there another order entitled to enforcement? Should you ask another state to decline jurisdiction? If no other state has jurisdiction, then a court must determine if it has the power to make the custody decision. If another state has jurisdiction, then you need to file a motion to dismiss for lack of subject matter jurisdiction under the UCCJEA. The Interstate Compact on the Placement of Children, or ICPC, establishes uniform legal and administrative procedures governing the interstate placement of foster children. Before a child in the custody of the state can be placed in a home in another state, whether it is a foster home or relative's home, certain requirements must be met to comply with the ICPC. The sending state, this will usually be Wyoming in your cases, must notify the receiving state of its intention to place the child in a home in the receiving state. The receiving state must then provide notice to the sending state that the proposed placement does not appear to be contrary to the interests of the child. The requirement applies whether you are placing a child in a foster home, a child care institution, or a pre-adoptive placement. In practice, the ICPC process includes a home study of the potential home and approval by the receiving state. This process is cumbersome and can take many months, sometimes years. If you have potential placements with relatives, non-custodial parents, or other families in another state, you should encourage the child's Department of Family Services worker to begin the ICPC process as soon as possible so that you can obtain notice from the receiving state that the proposed placement does not appear to be contrary to the interests of the child. Anytime you are considering placing a child in a state other than Wyoming, be sure you are following the requirements of ICPC, as any placement of a child in another state that doesn't follow ICPC is not a legal placement. This includes ensuring that DFS sends notice, requests a home study or information about the placement, and that the home study or information is returned to Wyoming before placement. All of this is done through a state's ICPC administrator. Every state has one. There is a conflicting case law as to whether or not the interstate compact on the placement of children applies when placing a child in another state with a non-custodial parent. In the absence of agreement of the courts and a decision from the Wyoming Supreme Court, the GAL program has instructed you to assume ICPC does not apply to non-custodial parents, as they still have parental rights if they are not the subject of an abuse or neglect proceeding. Knowing the federal laws that impact your work as a guardian ad litem is an important component in your overall responsibility to your child client. Be sure you have a working knowledge of all laws and review the details whenever the need arises. Now let's look at Section 7, Rules that Govern Your Work. Each case in juvenile court has one or more applicable court rules that you must know and understand. The rules of procedure for juvenile court are most important, as they affect all of your cases in juvenile court and deal with things such as discovery and timelines. There are 10 rules of procedure specific to juvenile proceedings. Rule number 1 outlines the title, scope, and definitions of the rules and directs that the Wyoming Rules of Evidence apply to juvenile proceedings. Rule number 2 governs the presence of the child in court, the presence and limits of the foster parent or other out-of-home placement providers, the exclusion of the general public, and notice to foster parents, pre-adoptive parents, or relative caregivers that they may have the opportunity to be heard. Rule number 3 dictates discovery and compliance by the state. It outlines matters not subject to discovery, prescribes discovery by other parties, delineates the procedure and timelines under which discovery must be furnished. Further, Rule number 3 dictates the continuing duty to disclose. It speaks to protective orders to restrict discovery. Finally, it allows that other orders may be passed which aid discovery and requires timely disclosure. Rule number 4 establishes the 5 business days prior to hearing time in which any report offered for consideration must be filed and served upon the parties. Rule number 5 establishes the right to counsel for respondents in juvenile actions, whether they are juveniles, guardians, or parents. This also includes proceedings subject to the Indian Child Welfare Act, which are subject to tribal court jurisdiction. Rule 5 further governs the notice and advisement of the right to counsel. In abuse and neglect cases, this right to counsel applies to the parents, but in CHINs and delinquency proceedings, it applies to the child. Rule number 6 gives authority to the courts to define procedures for conducting pretrial conferences. Rule number 7 allows that the parties may stipulate to any matter. It requires that the court accept stipulations to adjudication and disposition only if it determines the parties understand their rights and have had sufficient opportunity to consult with counsel. Lastly, specific rules for stipulations in Native American child cases are outlined. Rule number 8 provides the general requirements, qualifications of, appointment, and duties of a CASA. They must be trained in accordance with the national CASA standards and appointed by the court. They can only serve in abuse and neglect proceedings. Rule number 9 allows for agreements or plea bargains. The rule allows parties to agree that information gleaned from a parent or juvenile during the multidisciplinary process will not be admissible in a subsequent criminal case. Additionally, the rule allows that a juvenile's admissions or incriminating statements to a professional in the course of treatment will not be admitted into evidence in any criminal or delinquency case without the juvenile's permission. Rule number 10 prohibits juvenile proceedings to be delayed pending criminal proceedings in district or circuit court. It requires that all juvenile cases proceed pursuant to Wyoming statutory timelines. A GAL should be very careful about requesting continuances. As a guardian ad litem, you don't want to be the reason a case is delayed, so don't ask for one unless it is in your client's best interest, is necessary and justified. It is also incumbent upon you to object to any continuances that another party to the case requests, unless the request is clearly in your client's best interests. While the Wyoming rules of evidence apply to juvenile proceedings, there are some specific expectations as to what evidence may be received and considered by the court in abuse and neglect proceedings. In shelter care or dispositional hearings, all material and relevant evidence helpful in determining questions may be received by the court and relied upon for probative value. The parties or their counsel have the opportunity to examine and challenge written reports received as evidence and cross-examine persons making reports. Adjudicatory hearings require that only competent, relevant, and material evidence be admissible to determine the truth of the allegations. The Wyoming Rules of Civil Procedure apply to juvenile proceedings. The Wyoming Rules of Criminal Procedure apply to CHINs and delinquency proceedings when they are not inconsistent with the Juvenile Court Act. Having a thorough understanding of the applicable rules for juvenile court will help to ensure the best and most efficient result for your client during court hearings. As part of your preparations for court appearances, take the time to review these rules.